The federal courthouse in Baltimore that has stopped more Trump administration policies than any other building in America just lost its most powerful weapon, not because Congress passed a law, not because the Constitution changed. Justice Amy Coney Barrett said it herself. Federal courts no longer have the authority to block government actions nationwide. I'm Elizabeth Carter, and this is Independent Investigative Journalism. Before we go any further, I need you to do something right now. Hit that subscribe button. Click the notification bell. Leave a comment below telling me whether you've ever been personally affected by a federal policy that got blocked by courts. Share this video with everyone you know. This is the only official channel, and what I'm about to show you is happening in real time across every federal courthouse in America, and it's spreading. 1 minute ago, the Supreme Court's 6-3 emergency ruling in Trump versus Casa just changed the constitutional balance of power forever. Here's the core argument tonight in plain language. The highest court in America just stripped lower federal judges of their ability to protect millions of people from government overreach with a single ruling. This isn't about politics, it's about institutional mathematics. Tonight, I'm going to walk you through exactly what nationwide injunctions were, why the Supreme Court eliminated them, and who's about to eat the cost so you can see exactly how we got here and where this leads every American family. 3 separate federal district judges issued universal injunctions preventing Trump's birthright citizenship executive order from going into effect nationwide. That meant if you were born in Los Angeles, protected in Los Angeles. Born in Miami, protected in Miami. Born in rural Montana, protected in rural Montana. One court decision, universal protection. Justice Barrett's majority opinion just declared that era over. Translation: if the federal government wants to enforce a policy that violates your constitutional rights, you now have to fight them yourself, in your own courthouse, with your own lawyer, at your own expense. Every single person, every single case, every single time. Think about that. The Maryland federal court that blocked the citizenship policy, they're scrambling right now to figure out how to protect the same people without the tools they've used for over 2 centuries. The advocacy groups that used to file one lawsuit to protect millions, they're having emergency strategy meetings because their entire legal model just collapsed. And here's what nobody is saying out loud. This decision doesn't just affect immigration. It affects every single federal policy that impacts your daily life. Environmental regulations, labor protections, healthcare rules, financial regulations, consumer protections. What I'm about to show you is the domino effect that starts the moment federal courts lose the power to say no to federal overreach. And it gets worse. Since 1789, federal judges have had one nuclear option when the government violated the Constitution. Nationwide injunctions. One court, one judge, one decision that stopped illegal government action everywhere in America, instantly. For over 2 centuries, this power protected millions of people from federal overreach with a single ruling. Here's how it worked. When President Trump issued his executive order ending birthright citizenship on January 20th, 3 things happened within hours. Immigration lawyers filed emergency lawsuits in multiple federal courts. District judges in Maryland, California, and Washington examined the evidence. All 3 concluded the order violated the 14th Amendment and issued nationwide injunctions blocking enforcement everywhere. That meant every hospital in America knew the rules. Every state vital records office knew the rules. Every passport office knew the rules. One legal standard, universal protection. The Trump administration appealed directly to the Supreme Court. Justice Amy Coney Barrett, writing for the 6-justice majority, declared that the Judiciary Act of 1789 does not authorize nationwide injunctions that reach more broadly than needed to provide complete relief to the parties to a case. Translation: federal courts can only protect the specific people who filed the lawsuit, not everyone else facing the same illegal government action. Let that sink in. The legal mathematics are brutal. Before this decision, one successful lawsuit protected 330 million Americans from unconstitutional federal policies. After this decision, each person harmed by government overreach must file their own individual lawsuit, hire their own lawyer, and fight the federal government alone. Between 2017 and 2025, federal courts issued nationwide injunctions blocking 47 Trump administration policies that would have affected over 15 million people directly. Immigration enforcement changes, environmental deregulation, labor protection rollbacks, healthcare access restrictions. Each injunction meant universal protection with one court filing. Now watch the domino effect that Justice Barrett just triggered. First domino, executive order issued ending birthright citizenship. Second domino, multiple courts could have blocked it nationwide, but only for specific plaintiffs. Third domino, Supreme Court eliminates nationwide protection, leaving millions vulnerable to enforcement while individual lawsuits proceed. Here's what makes this historically unprecedented. Chief Justice John Marshall established the principle of nationwide judicial review in Marbury v. Madison in 1803. Federal courts have used universal injunctions to stop government overreach for 221 years. The Supreme Court just eliminated that protection in a 47-page decision issued on emergency appeal. Constitutional law professors across the country are calling this the most significant restriction of federal judicial power since the New Deal court packing crisis. Professor John Harrison at Stanford Law School told legal reporters, "This fundamentally alters the relationship between the executive branch and the federal judiciary. The executive wins by default until each individual case works its way through the system." But here's what the legal experts aren't telling you about what happens next. The Maryland federal court that originally blocked the citizenship policy, within 6 hours of the Supreme Court decision, they certified a nationwide class action lawsuit covering every person affected by the policy. Justice Samuel Alito specifically warned against this exact maneuver in his concurrence. The constitutional chess match is just beginning, and it gets worse for anyone trying to challenge federal power. Let me show you the mathematics of legal protection in America before and after this Supreme Court earthquake. Before the CASA decision, one lawsuit equals universal protection for 330 million Americans. After the CASA decision, each affected person must file individually, hire their own attorney, fight the federal government in their local courthouse, and hope they can afford years of litigation. That is not abstract legal theory. That is the new reality for every policy area that affects your daily life. Immigration enforcement rules that determine who gets detained and who goes free. Environmental regulations that control the air you breathe and water you drink. Labor protections that govern your workplace safety and overtime pay. Healthcare rules that determine what treatments your insurance covers. Financial regulations that protect your bank deposits and retirement savings. Under the old system, advocacy groups could file one strategic lawsuit and protect everyone. Under the new system, millions of individual Americans have to sue the government separately to get the same protection. Justice Samuel Alito saw this coming. In his concurrence, he explicitly warned that district courts should not view today's decision as an invitation to circumvent the ruling through nationwide class certification. He was talking about exactly what happened 6 hours after the decision came down. The Maryland federal court that originally blocked the birthright citizenship policy immediately moved to certify a nationwide class action on behalf of every person affected by the executive order. Translation: they're trying to use class action lawsuits to recreate the same universal protection that nationwide injunctions provided. This is constitutional warfare in real time. Here's the irony that should make everyone angry. The Supreme Court decision was supposed to prevent judicial overreach and reduce complex litigation. Instead, it's creating the most complex legal battlefield in American history. Lawyers are scrambling to find workarounds. Courts are inventing new procedures. The federal government is testing enforcement in friendly jurisdictions while avoiding hostile ones. Corporate America is panicking. Before CASA, companies could rely on advocacy groups obtaining nationwide injunctions to block harmful federal regulations. Now every business faces a choice: file expensive individual lawsuits in multiple jurisdictions, or comply with potentially illegal federal rules until the Supreme Court eventually sorts it out. The National Association of Manufacturers told industry reporters, "Our members now face years of legal uncertainty and millions in compliance costs while waiting for uniform national standards. We may be forced to follow different federal rules in different states depending on local court decisions. And it gets worse for people trying to challenge federal overreach. Look at what this creates on the ground. In states with Trump supporting federal judges, the new citizenship rules get enforced immediately. In states with Biden-appointed judges, individual lawsuits might provide temporary local protection. Same federal policy, different enforcement, depending on your zip code. Environmental groups that used to protect national parks with single lawsuits now have to file separate cases for each protected area. Labour unions that challenge workplace safety rollbacks nationally now have to organise individual workers to sue in each affected region. Civil rights organisations that stop discriminatory policies everywhere with one filing now have to build case-by-case protection. The American Civil Liberties Union's federal policy director admitted to Constitutional Law reporters, "This decision forces us to choose between spreading our limited resources across hundreds of individual cases or focusing on a few strategic battles while millions of people lose protection." Stanford Law School's analysis published yesterday shows the brutal mathematics before CASA. Successful constitutional challenges provided immediate nationwide relief in an average of 18 months. After CASA, achieving the same universal protection through individual lawsuits and eventual Supreme Court review will take an estimated 4 to 7 years. Think about that timeline. 4 to 7 years of enforcement against people who cannot afford individual lawyers while waiting for the constitutional questions to reach the Supreme Court. This isn't about streamlining the legal system. This is about tilting it permanently toward federal power and away from individual protection. And it gets worse because the Supreme Court kept all the power for themselves. Let me tell you about Maria Santos. Immigration attorney, Baltimore, 15 years building a practice around nationwide injunction work. This morning she called every client with pending citizenship cases and delivered the same devastating message: "I can no longer protect all of you with one lawsuit." Maria told legal reporters, "Before today, I could file one emergency motion and know that every family facing the same unconstitutional policy would be protected immediately. Now I have to tell parents that I can only represent them individually, and they need to find $25,000 for litigation that might take years." Translation: the legal protection that used to cost one filing fee and benefit millions now costs individual families more than most people make in 6 months. Let that sink in. Maria Santos is not alone. Immigration attorneys across America spent today recalculating their entire business model. Public defenders are realizing their constitutional challenges now protect only their immediate clients. Civil rights lawyers are looking at resource budgets that cannot possibly cover individual representation for everyone who needs protection. Now let me tell you about James Mitchell. Small business owner, operates 3 family restaurants across Maryland, Virginia, and Pennsylvania. This morning he discovered that the federal labor regulations he thought were blocked nationwide only got stopped in Maryland. His Virginia location faces different overtime rules. His Pennsylvania restaurant operates under a third set of federal guidelines. James told industry publications, "How am I supposed to run a business when the federal government enforces different versions of the same policy in different states? My payroll company said they've never seen anything like this. Same federal agency, same regulation, 3 different enforcement standards depending on which courthouse blocked what." Think about that operational nightmare. One business owner trying to comply with federal law that means different things in different locations, because courts can only protect people locally. Here's what James is facing in mathematical terms. Maryland Federal Court blocked the new overtime regulations for local plaintiffs. Virginia Federal Court allowed enforcement to proceed pending individual challenges. Pennsylvania Federal Court issued a temporary restraining order covering only the businesses that specifically sued there. Same federal policy. Three different realities. And James Mitchell's family restaurants are caught in the constitutional crossfire. But let me tell you about someone who benefits from this new system. Sarah Chen works as a federal enforcement officer for the Environmental Protection Agency. She told government employee publications, "For the first time in my career, I can actually enforce regulations without wondering if some federal judge in Texas is going to block our work nationwide tomorrow." Sarah represents the other side of this constitutional equation. Federal workers who spent years watching their policy enforcement get stopped by single court decisions now have more consistent authority to do their jobs. That is what I call the enforcement lottery. Some communities get protection through local court challenges. Others face immediate federal enforcement, while legal challenges play out. Your constitutional rights now depend on your zip code and whether local advocacy groups can afford individual litigation. Let me tell you about Rosa Martinez. Community organizer, Phoenix. Works with immigrant families facing the new citizenship rules. She told community newspapers, "We used to know that a successful court challenge in any federal district protected families everywhere. Now we have to tell people that protection might exist in California, but not Arizona, or in Texas, but not New Mexico." Rosa Martinez is watching the constitutional protection system fragment in real time. Families with identical legal situations getting different outcomes based on which federal court has jurisdiction over their case. And Rosa Martinez is not alone. Community organizers nationwide are holding emergency strategy meetings to figure out how to provide legal support when the old system of universal protection through single lawsuits no longer works. These individual stories reveal something much bigger happening to American democracy. Here's the three-domino democratic accountability chain that every American needs to understand. First domino, federal courts lose the power to issue nationwide injunctions, stopping government overreach. Second domino, the executive branch gains massive enforcement advantages because individual lawsuits take years to reach universal protection. Third domino, citizens lose their most effective mechanism for challenging federal power quickly and affordably. This isn't about politics, it's about institutional mathematics. When democratic institutions lose the power to check each other effectively, executive authority expands to fill the vacuum. We've seen this pattern in other democracies. Hungary's Viktor Orbán used similar judicial limitation strategies to consolidate power. Turkey's Erdogan systematically reduced court authority to challenge executive actions. Poland's Law and Justice Party restricted judicial review of government policies. I'm not saying America is becoming Hungary. I am saying that when courts lose the power to provide immediate protection against government overreach, democratic accountability gets weaker. Professor Jennifer Mason at Georgetown Constitutional Law Center published analysis yesterday showing the mathematical impact. Before the CASA decision, successful constitutional challenges provided immediate universal relief in 18 months on average. After CASA, achieving the same protection through fragmented individual lawsuits and eventual Supreme Court review will take 4 to 7 years. Translation: the window for constitutional protection just expanded from 18 months to half a decade. During that time, federal policies that violate your rights get enforced while you wait for the legal system to catch up. Let that sink in. Here's what makes this historically unprecedented. The Supreme Court kept all the emergency authority for themselves. Justice Brett Kavanaugh explicitly noted in his concurrence that the court retains its vitally important responsibility to resolve applications for stays or injunctions with respect to major new federal statutes and executive actions. So the Supreme Court eliminated the power of lower federal courts to provide immediate constitutional protection, but preserved their own ability to grant or deny emergency relief. That is concentration of power, not distribution of power. International constitutional scholars are watching this development with alarm. Professor Hans Müller at Oxford University's Centre for Constitutional Studies told International Legal Publications, "The American system historically provided multiple layers of judicial protection against executive overreach. Eliminating nationwide injunctions while preserving Supreme Court emergency authority creates a dangerous bottleneck where 9 justices control constitutional protection for 330 million people. Think about that institutional mathematics. Before CASA, roughly 180 federal district judges and 13 courts of appeals could provide immediate constitutional protection. After CASA, only the Supreme Court retains that universal authority. Now watch the timeline for what becomes harder to challenge in the coming years. Immigration enforcement policies that affect millions of families, environmental regulations that determine industrial pollution standards, labour protections that govern workplace safety across entire industries, healthcare rules that control insurance coverage for chronic conditions, financial regulations that protect consumer deposits and retirement investments. All of these policy areas now face the same enforcement reality. The federal government can implement potentially unconstitutional rules immediately, while individual challenges work their way through years of litigation toward eventual Supreme Court review. Here's the unintended consequences. Irony that should concern everyone, regardless of political affiliation. The CASA decision was supposed to reduce judicial activism and prevent single judges from imposing their will on national policy. Instead, it may increase executive activism by removing the most effective check on federal overreach. When courts lose the power to say no quickly, executives gain the power to act first and worry about constitutional questions later. That is not a conservative outcome or a liberal outcome. That is an authoritarian outcome. Academic research published by the Brennan Center for Justice shows that democratic institutions maintain public trust through visible checks and balances between branches of government. When one branch loses effective oversight power, public confidence in institutional fairness declines measurably. Dr. Rebecca Thompson at Yale Law School told Constitutional Law Reporters, "The CASA decision doesn't just change legal procedure, it changes the psychological relationship between citizens and government. People need to know that constitutional violations can be stopped quickly, not just corrected eventually. Here's what every American needs to understand about the timeline ahead. Between now and 2028, the Trump administration will test the boundaries of this new constitutional landscape aggressively. Immigration policies, environmental rollbacks, labor deregulation, healthcare restrictions, financial industry changes, each policy will face the same enforcement mathematics. Immediate implementation, individual legal challenges taking years to provide universal protection, Supreme Court review as the only path to nationwide constitutional relief. That institutional reality is permanent unless Congress acts or the Supreme Court reverses itself. Here's the reality check that every American needs to accept right now. This Supreme Court decision is permanent unless Congress passes legislation restoring nationwide injunction authority, or the court reverses itself in a future case. Neither outcome is likely in the current political environment. The constitutional power shift we just witnessed is the new American legal reality. Here's the accountability question I want you to answer in the comments below. Do you believe federal courts should have the power to stop government policies nationwide with a single ruling, or should each person affected by unconstitutional federal actions be required to file individual lawsuits and fight the government separately? Think about your answer carefully because it determines the constitutional protection system your children will inherit. If you believe courts should retain nationwide injunction power, you need to contact your representatives in Congress immediately. The House Judiciary Committee and Senate Judiciary Committee have authority to pass legislation clarifying that federal courts retain universal injunctive authority under the Judiciary Act. But that requires political pressure from constituents who understand what's at stake. If you believe individual litigation provides better protection against judicial overreach, then you're watching the system work exactly as the Supreme Court intended. Federal policies get implemented immediately, while constitutional challenges proceed case by case toward eventual resolution. Either way, you cannot remain neutral on this question. The institutional mathematics affect every area of federal policy that touches your daily life. Here's what you can do beyond calling Congress. Support organisations that provide legal aid to individuals who cannot afford constitutional litigation. Vote in state and local elections that determine which judges hear federal cases in your jurisdiction. Stay informed about Supreme Court composition, because they now control the only path to immediate constitutional protection. The timeline for when these impacts become most visible runs from 2026 through 2028. Immigration enforcement, environmental regulation rollbacks, labour protection changes, healthcare policy modifications, financial industry deregulation. Each policy area will test the new constitutional landscape, where federal power faces reduced judicial constraints. I'll be here documenting every major case that tests the post-CASA legal system, every successful individual challenge, every federal policy that proceeds unchecked while constitutional questions work through years of litigation, every Supreme Court decision that grants or denies emergency relief under their preserved authority. Because this story is not about legal procedure, it is about the relationship between government power and individual protection in American democracy. Subscribe to this channel and hit the notification bell, because the constitutional consequences of the CASA decision will unfold over months and years, not days and weeks. Leave a comment with your answer to the accountability question. Share this video with everyone who needs to understand how federal judicial power just changed permanently. This is independent investigative journalism following evidence wherever it leads.